Anita, how are you?
Hello, Maya. Good to see you again. I am
Well,
doing well. How are
good
you?
to see you too. I'm doing very well. Always nice to see you. And well, today I'm excited because we are going to be talking about something very important that you've been working on, and it is your motion for the Law Society. So I will let you give us more details about what this motion is about, why you're bringing this motion, and what can people do to support you in this motion.
Well, thanks, Maya, for your interest in this issue. I'm happy to say that there is quite a lot of interest in my little motion. I will be presenting a motion to the annual general meeting of the Law Society of Ontario. The motion will happen on Thursday, September 18 at 5:15 p.m., or at least that's when the AGM is starting. The AGM is virtual and we can all attend virtually. So we'll talk
Mhm.
about how you do that. Any licensee of the Ontario Bar, and that includes lawyers and paralegals who are licensed, unless your license is suspended. In that case, you can't help me right now, unfortunately. But anyone who's not suspended on September 18th, you'll be able to attend if you register. So at the end of the video, or maybe somewhere in the description, we can include the
Yeah.
link for you to register to attend. But yeah, so I'm bringing this motion to the Law Society, and it's a motion for disclosure of financial information, very specific financial information. I'm looking to the Law Society to disclose to licensees, to lawyers and paralegals that they govern, and also to the public, um, whose interests they are to protect. I want them to disclose the global cost of what it has cost us to deal with both before and in the aftermath of their CEO's salary and the scandal around that. So I think, as most licensees will know, it came to the attention of Convocation at some point last year. I think in around November of 2024, our elected benchers found out that in June of, I think it was also in 2024, um, the uh, the CEO is given this huge increase in salary from her base salary of 600,000 to just under 1 million for her salary, but she was also given another $267,000 sort of lump sum payment in relation to some pensions adjustment or something. I don't fully understand it, but the point is basically doubled, went from 600,000 to 12 something. Uh, and that money was promised to her and given to her by now Superior Court Justice Jacqueline Horvat, who was the previous treasurer of the Law
Mhm.
Society, by signing a contract on her own when the decision for any changes to the salary and compensation regime of the CEO should have gone to convocation. So that didn't happen. This was brought to the attention of now Treasurer Wardle and then Convocation. And as we all know, the O'Connor report was generated as a result. So retired Court of Appeal Justice Dennis O'Connor, through Board and Ladner, was asked for what the Law Society will say is a legal opinion, although it does look like an investigation into what happened. That report was generated, I think, in February of 2025 or so. And then the profession got very, very upset, very angry when we learned both the amount of money that was promised and given to Diana Miles, the former CEO, and also just, how long that information was kept from us and how hard we had to fight to get the O'Connor report released. And you'll remember, Wicked, Lambda,
Mhm.
FOLA, a bunch of legal organizations, DCAO as well, I think, advocated for release of the O'Connor report. And eventually that was disclosed. And basically, the profession lost its trust and confidence in the Law Society. So the Law Society's answer to that was to hire public relations consultants and to manage their image and to try and regain our trust. So they hired a professional reputation and image management consultant, and then after that, they've recently hired, I think, a York law professor who specializes in governance to review all their bylaws and give them suggestions on how to write better bylaws. And in between there, or before all this happened, former Treasurer Horvat, now Superior Court Justice Horvat, had retained the services of several private law firms, and the compensation committee had retained several other firms to do compensation reviews, human resources experts. So what I'm looking for, this is a lot of money. So,
Hmm.
the $1 million to or thereabouts to the CEO, then the cost of Borden Ladner and Justice O'Connor for the investigation, the image managers, the governance consultant, and the law firms that provided advice up front. And I'm sure I'm missing something, but it's a long list of what I suspect are very expensive services. So licensees were already so hurt and so angry by this big amount of money that to most of us who work on legal aid for vulnerable people, for us to see that kind of money, to get $1 million or more dollars, how long would that take most of us? Maybe a decade. If you're
Hmm.
exclusively working on legal aid, making maybe $100,000 if you're lucky a year, $1 million is a big ticket item. And people were mad about that. And I think the Law Society implicitly appreciates that we would only be angrier if we knew what this is really costing us. So I want to know, and I hesitated because I thought about it. So I had always thought I would bring this motion since this news story broke, in the late winter of whatever it was, December, January, February 25. I had started thinking about what is all this stuff costing, including the O'Connor report. And so I always thought, I'm going to look for this disclosure from the Law Society, see if they'll tell us what they're spending. But then, I took the summer off from thinking about this stuff, mainly because I was getting too angry. So I put it aside. And then I suddenly realized that the last day to file the motion was coming up on August
Hmm.
11th, just this week. And then I thought, well, maybe I won't do it after all. Why do I have to be the one person to do it? And then I realized, no, I'm going to bring the motion for two reasons. One, I actually want to know, and I don't see any other way that we would ever find it. So I personally want to know what this is costing, because I think it's in the millions. I think if you add it all up, it's just a guess. We shouldn't have to guess. But I think if you include the million plus to Diana Miles, it's going to be some number of millions of dollars when you add all this up.
Hmm.
So personally, I want to know. But beyond that, um, I know because I've spoken to so many people that there is not one practicing lawyer or paralegal who looks at what happened here and thinks that's fine. Nobody thinks this was fine. There's such a breach of trust and confidence. And people want to see accountability and transparency. And this is an opportunity for the Law Society, who says they want to be accountable and they want to be transparent. Here's their chance to try and put their money where their mouth is, so to
Yeah.
speak, and be transparent and just tell us. So I feel like I'm speaking for the profession because um, the other, you know, 66,000 lawyers, or whatever it is, 60,000 lawyers, 12,000 paralegals, the other 60 or 70 legal professionals governed by the society are not going to do it because people are terrified. This is our governing body, and people are scared they're going to be audited. They're worried the Law Society is going to come after them if they speak out. And so knowing that this is a very widely shared concern about what's happening at the Law Society, I just thought, well, if no one else is going to do it and no one else is going to do it or has done it, I'm just going to do it. It's a legitimate inquiry. So I did it. It's an extremely long answer. You said, what's the motion? There's the motion. That's why I brought the motion.
Yeah, no, that's thank you, Anita, for this explanation. And it is important for people to understand what this motion is about. And it is actually important because it was something I remember when we were going through the time before the O'Connor report was disclosed. Everybody was angry. I mean, we can feel the tension. It was what all lawyers were talking about. And this was not just criminal lawyers, it was all lawyers from all areas of law everybody was frustrated, everybody had questions, and there were no answers. So, yes, the O'Connor report provided some answers, but we still have many questions that are still unanswered. And it's not because that report was released that that's it. It's the end of the story. That's just the beginning, because that's when we started to understand what was going on. But we still have more questions. And quite honestly, I mean, I don't think that the relationship between lawyers and the Law Society is fully reestablished at this point. I mean, there's still a lot of work to do. And I mean, we still need to see from the Law Society continued disclosure and continued communication. I mean, one of the frustrations that we also had, if you remember, is this lack of direct communication between lawyers, the profession, and the Law Society. And I don't think we had much communication since the O'Connor, right? Like a
No,
report was disclosed.
no, so I agree with you. I do speak to a lot of lawyers and paralegals about these issues. I'm interested in our governance issues, and the trust and confidence has not been restored.
Mm-hmm.
The relationship has not been repaired. And unfortunately, Law Society keeps doing things that, even though they pay lip service. So the messaging that does come out is, we know there's been a problem. We know you've lost trust and confidence. The most important thing, Treasurer Wardle has messaged repeatedly, the most important thing is to reestablish public trust and confidence in the Law Society, including the trust and confidence of licensees. But in fact, almost nothing has been done in that regard. So
Yeah.
the only thing that they have done is retained a law professor as a governance expert to review their bylaws and try and address, I guess, some of the recommendations in the O'Connor report that identified gaps, like they didn't take notes when they
Yeah.
had committee meetings. They didn't have terms of reference for their committees. Nobody knew where to find the bylaws. And things that are pretty common sense. It was fairly shocking how disorganized they were, how much documentation they either never created or couldn't find, and how much benchers were on these committees were professing not to know what the bylaws were for the Law Society. If you sit on the governing body of something, you should have a familiarity with the bylaws that govern the organization. I sit
Yeah.
on a lot of boards, and the first thing I do is ask for and review some bylaws so I know the bylaws are pretty important in any organization. So I agree with you. Nothing's been done apart from we're going to review our bylaws and the governance expert is going to provide some advice. My own view is that there was actually nothing wrong with the bylaws. The incident that um, came to our attention that caused this scandal when Justice O'Connor looked at the bylaws and asked the former Secretary of Law Society, Jim Varro, about this, who Mr. Varro was familiar with the bylaws. It was very, very clear in the existing bylaws that the CEO's compensation had to be referred to the board convocation for them to consider and vote on. So it's not an answer to what happened there to say, well, we need better bylaws, or somebody has to read the bylaws and be more clear in the bylaws.
They need to apply the
The
bylaws
existing
that do
bylaws.
exist.
So
Yeah.
it's a in my personal views, this is a distraction. So if the Law Society says there were problems with our governance structures and we're going to have an expert advise us, so and Treasurer Wardle and Law Society keep saying to avoid a recurrence. Well, the way to avoid a recurrence is to make sure that you don't have people acting in a rogue fashion. Make sure people don't go off and sign up contracts on their own without authority. And show some accountability for what happened. So
Yeah.
people are looking for accountability for what happened. There were benchers involved on the compensation committee, and their roles are detailed in the O'Connor report. So there has been no public facing communication with respect to anybody being held accountable for what happened. Treasurer Wardle wants to move forward. And what was really interesting, the other thing that did happen is, of course, all the benchers had an opportunity to choose their leader for the next 2 years. So in June of 2025, there was an election and it was a contested election, and three different benchers put forward three very different visions for how to move forward. One of them wanted to ensure there was accountability for what happened and had a plan of action. One of them sort of wanted to strike a balance between making sure that there is accountability and transparency around the CEO scandal,
Hmm.
but also, making sure the ordinary work of convocation can continue. And Treasurer Wardle is really about being forward looking. And I understand it's fair that Treasurer Wardle and the Law Society don't want the next 2 years that they have to govern to be all about looking at this one incident. That's fair. They need to do the ordinary important work of convocation, but they also need to show us in a serious way how they are accountable for what happened. They also need to, in my view, explain to us how they've spent our money
Yeah.
on this incident and whether any of it was necessary, and let us evaluate who they gave the money to and for what. I think most lawyers and paralegals are outraged that our hard-earned money is being spent on managing the Law Society's image and reputation in the wake of a scandal caused by benchers involved in the incident. Why are you and I working at legal aid rates of $100 an hour for vulnerable clients and retaining 18 cents on the dollar of that when we get paid after overhead and insurance and fees? Why are we paying hundreds of thousands of dollars, no doubt, to image management consultants because the Law Society was exposed for having acted outside of their bylaws and giving a ton of money to someone without the
Yeah.
necessary authority? Why are we paying for them to try and manage that to regain our trust? Why are we paying for that? And how
No,
much?
I know, and that's really what was very frustrating um, to many lawyers is that because we all recognize that everything that was being done, even the salary increase, was being made with our money,
Our money.
and nobody was aware of what was like everything was happening behind the scenes. Only a few knew, not even all the benchers. Some benchers had no idea what was going on, and they were taken by surprise. And it was just a very bad look on everyone. And so just the acts of a few in the Law Society just had an impact and made us lose trust maybe in some people who were there who had nothing to do, but because it was just so outrageous what happened, that we were all shocked and we were all
Yeah.
frustrated. And it was just people felt like it wasn't fair. And another problem that we have with the Law Society is, as you know, Anita, we all have to pay depending on the year of call. So it doesn't matter how much you're making. Like the what we pay is not reflective of how much we make. It's not like if you make more, you pay more, and if you make less, you pay proportionally to how much you're making. It's a price that's imposed depending on the year of call, and some people can afford it better than others, but they all have to pay. So it was just really,
You're 100% right, Maya. So definitely most of the benchers who sit in convocation were absolutely 100% not involved, had no direct
mm,
knowledge. This this thing with Diana Miles went down between Treasurer Horvat, Diana Miles, and in the know were, to some degree or other, yet to be determined fully, I guess, but based on O'Connor, some people on the compensation committee, there was a lay bencher, paralegal bencher, a couple of lawyer benchers, and Treasurer Wardle was there for some of the meetings, observing in anticipation of perhaps becoming the next treasurer back then. So maybe it was 23. Um, so a handful of people had some tangential or more direct involvement, but the rest of them had no knowledge of that.
mhm,
However, all of the rest of them have been privy to and have voted on and decided to take a certain direction going forward. As a majority bencher chose to re-elect Treasurer Wardle in June of this year. They had a choice. They wanted to keep the man who was the treasurer when this, well, not quite when the document was signed, because he became treasurer like a few days, I think, later or the next week. But it's an implicit endorsement of how he handled the wake of the incident to re-elect him. So they chose by majority vote to re-elect him, showing, I think, and I think he has said, and Law Society has said that they're showing their confidence in him because they want him to continue as treasurer for another 2 years. To me, it's an implicit endorsement of how he handled the situation in the wake of the incident, which was to resist disclosure of the O'Connor
Hmm.
report until and unless it became almost impossible to do so because of the escalating pressure that lawyer organizations and licensees were putting on him. That's one thing. But all of the rest of the benchers, by majority vote, have also endorsed these additional costs: the image management, the reputation management, the governance consultant, and I forget what else. And you really have to wonder about that because we're talking about significant amounts of money. Is this an appropriate and is this the best use of their money? I often wonder if the Law Society understands what the real issues are. And this is my underlying problem with them. I think they're very much out of touch with the reality of how we, in legal aid practices, in sole practices, serving criminal law clients, I think as an institution, they continue to be very much out of touch with the reality of how we earn a living, how difficult it is, how stressful it is,
Yeah.
the mental health crisis among the bar, the problem that there are not enough articling spots for all the students we're allowing the law schools to produce. So if the Law Society has millions to burn, to give to Diana Miles and to the image consultants, is there some reason why the Law Society doesn't pay you and me so we can pay money to an articling student that they're mandating we pay to a student so that we can open up an articling spot or more articling spots, right? So there's, for example, this is one of many pressing, huge problems that the Law Society could be spending money on, right?
Hmm.
They could take a certain amount of money and either pay an articling student's minimum salary that they have set and is mandatory for an articling student to be paid, give me the money to pay to an articling student, and I will give them a spectacular articling experience.
Yeah.
And they'll get a job, and it's very, very hard for sole practitioners, small law firms on legal aid tickets in criminal law to afford to pay a living wage to an articling student. Meanwhile, they don't have jobs or subsidize it to a degree. Give me 10 grand
Yeah.
toward the salary of an articling student. And you're doing something like that would address a lot of problems. It would create articling positions that are very hard to come by. It would support articles in serving vulnerable populations in small firms and sole practices in criminal law. It would help retain women in the criminal law. There's a million things you'd be solving with those millions of dollars. But instead of that, you're giving it to a CEO because you're worried. The O'Connor report makes it clear that what Jacqueline Horvat, Treasurer, now Judge Jacqueline Horvat, was worried about, what the Compensation Committee was worried about, was that Diana Miles might walk out the door if she didn't get a raise significantly upward of $600,000. So their biggest problem appears to be they can't find someone to do this essentially administrative job for as little as $600,000. Well, I have news for them. I know lots of people who would do it for a lot less.
Yeah.
They would do it part-time.
That's the thing. Like even the original salary was a lot
Too much.
before the increase. So
Way
I mean,
too much.
yeah.
But that's what they think the biggest problem is for the profession, right? They panic. Well, who's going to take this job for a lowly $600,000 to manage the admin side, the operation side of the Law Society? I don't think that's the biggest problem facing our profession. So if you have money to burn that you have collected from the $2,500 or so that we each pay every year, that takes us a long time to work to get, if you have squirreled that money away, so
Yeah.
you have these discretionary funds, then rather than the photo ops to feed the hungry, right? Because they get together a bunch of Bay Street lawyers every once in a while to do a soup kitchen for homeless people, and that's how they contribute. And I don't, I don't fault them for doing that. That's nice, but I think the Law Society can address actual problems in the profession, problems that young students, law students, young lawyers have in accessing articles and work, that the mental health crisis for the profession, they should expand therapy and services to address the mental health issues. They should be supporting those of us who are struggling to ensure that there are structural supports and reduced stressors for us so we can stay in the profession for longer. They should be bolstering their parental leave supports. Right now, you need to be able to prove that you make less than $50,000. I think the year before you apply for any kind of parental support through the Law Society. There, whatever the criteria are, very few people are eligible for them. And
Yeah.
ultimately, even if you get it, it's ultimately a few $100s a week or something. It's really, or maybe even
Hmm.
a month. So you have money to burn, give it to sole practitioners in the criminal law who are women, who are defense lawyers, who are about to become mothers. So you keep them in the criminal law when you know we're hemorrhaging women there. So I mean, I can point to a dozen bigger problems than where, oh, where will we ever find someone to help us in this position for just the $600,000.
So,
But
yeah.
all of this expenditure relates to that scandal. And there may be other expenditures that we don't know what they are. These are just the things identified within O'Connor or made public since then. So my motion also asks the Law Society to undertake to disclose any other related expenses that we don't know about and any expenses going forward that have yet to be incurred as they incur them. And I have given them until December 31, 2025 to make the disclosure.
And what if they don't make the disclosure, Anita?
Well, so it's interesting. In my line of work, I represent people with mental health issues, and um, when I do a lot of speaking engagements, and people often ask me, the most commonly asked question of me is, Anita, have you ever had a client who gave you instructions that were not in their best interest? And what do you do then? And I say to people, I'm not sure I've ever had a client who's given me instructions in their best
Mhm.
interest. So, in the same way, in answering this question, you know, ever since my motion has been made public in various legal media and on my blog and socials, um, a lot of colleagues, some of whom I know, some I know well, some I know a little, and some people I don't know, have very kindly, with the best of intent, privately messaged me to say, it's wonderful that you have the strength of character and the energy to move forward with this motion. But I just want to let you know very gently and gingerly that it's probably going to fail. Just so you know, so
Yeah.
you're not shocked. And I just want to be clear, I will eat my hat if the Law Society discloses any of this information. So it's not that I don't think they're going to do it, or I feel certain that one way or another this information will not be disclosed. And so I'm not deluding myself thinking that I will simply come to the AGM and say, could I please have an accounting of the following itemized
Yeah.
invoices? And they'll go to a drawer and pull out the invoices and
Yeah.
share the screen. I don't think that's going to happen. I think it's likely my motion won't pass, or they'll find a problem with it, or it'll be deferred, or it'll be modified, or perhaps they'll promise that they'll strike a committee to think about disclosing some summary amount, but they're not going to disclose this information to us. And so, knowing that, why am I doing this? Well, first of all, the information I'm asking for should take roughly 5 minutes or less to find and provide, because I'm asking for somewhere between 6 and 8 invoices, or final invoices. So these are all service providers that provide a service to Law Society. Somebody got the invoices and somebody has paid them.
If they track them, but one of the problems is that they don't keep track of anything, right?
Well, if they've lost millions of our dollars, then let them
Yeah.
answer that they can't find the receipts. No, they're going to talk about privacy rights of service providers. They're going to tell us, well, it's not fair to the private law firms that provided Jackie Horvat an opinion. It's not fair to Board and Ladner that we're asking to see what it costs for the investigation. Although, and I don't fault them for that investigation. It was an important investigation, and we got a lot of important answers. Um, but if they have kept any receipts, as you know, Maya, the obligations for us to keep records of
Yeah.
invoices and disbursements. And when you bill legal aid for a disbursement, for the cost of a transcript or the cost of travel, or the cost of, hospital
You
records in
have
my
to have
case,
evidence.
I have to produce every
Yeah.
invoice, every dollar, when we used to, before we went paperless, we would charge 10 cents a page for photocopies to legal aid on a file. And I got letters from them. I remember saying, well, why did you charge $86 for photocopies that you made in your office? And I said, because I have to pay for the paper. And so I'm allowed to bill 10 cents a page. So if I charged $86, then I probably made 860 pages or whatever, made,
Yeah.
yeah, right? That's why. And they said, well, there's no invoice or receipt. And I said, yeah, I'm using like a photocopier in a shared chambers. It counts the numbers. It doesn't deliver a receipt or an
Yeah.
invoice. Do you want me to make an invoice? So hours of conversations and emails and letter writing goes into justifying my $80 of photocopying that I'm billing to legal aid because I'm accountable. Legal aid's accountable, it's government. But the Law Society is not going to tell us how much they paid to Board and Ladner, to the other law firms, to the image consultants, and to the governance expert. They're not going to tell us. So why then bring the motion? Well, first of all, I want the information. So on the off chance that we get it, I'm asking. Second, we can't just be mad at them all the time that they're not telling us stuff
If we
unless
do.
we ask.
Yeah.
It's like the lottery, right? You can't win if you don't play. So you can't be angry. And I think ultimately I'm just looking forward to being very angry when they refuse to give me the information. So in order to be, legitimated in my anger, I have to first ask. I have to give them an opportunity to refuse me so
Yeah.
I can then complain that they refuse to disclose this information. But all joking aside, I'm doing it on behalf of the profession.
Hmm.
We have to do something. We have to prod and probe, let them know we haven't forgotten about this stuff, and try and put pressure on them to be more transparent and accountable because we're entitled to that. And somebody has to do it. And if you don't ask the tough questions, they're not going to voluntarily start publishing expenditures. They're not. So we definitely, I think as a profession, we owe it to ourselves, we owe it to our clients, we owe it to the public to hold them accountable. They're supposed to be regulating us, but they don't seem altogether that interested in governing or regulating themselves. And we need to see what they have done. The other thing is, we elected these people, right? So every 4 years, we go through this spectacle of an election of benchers to convocation where they vie for our votes, right? And this last one was, I think, an embarrassment to the profession with the amount of vitriol and bile and infighting and bullying, that went on, forcing us to vote for this many people in a group. Uh, and when they want our votes, they tell us that it's very important to elect people who will represent us, elect people who know the reality of our practice, because they will represent us. And then we expect, because when we elect our politicians, Rob Ford, when he was a counselor, you could call him and say, what are you doing, Rob, about my lead pipes or my garbage pickup? So we think of electing people to represent us as them being accountable to us and that we can follow up, they will consult with us. But actually, that's not how this works. Because
Hmm.
once they get in there and you try and ask them, what are you doing? They say, sorry, can't tell you anything. Venture code of conduct, confidentiality. And our job is actually not to serve you or answer to you. Our job is just protecting the public from you. So then why then don't come to us for our votes. And if you're going to come to me for
Yeah.
my vote next
Yeah.
time, then be responsive to when I identify a problem that it's not just me personally, but when the profession says, You have an accountability and transparency problem. We don't trust you. How are you going to govern us if we don't believe in you? Then start answering that question.
Yeah.
And
And I do want to stress on the point that you're making, Anita, which is a very important point. It is up to us to take action and to do something. Nothing's going to happen if we're just sitting and watching and complaining and being frustrated. And unfortunately, this is something that we're seeing more and more of in the profession, not just with this situation, but in other situations. We just see a lot of problems going on that are affecting defense lawyers, especially. It's always defense lawyers who keep losing the rights or the privileges that they have. And not a lot of people are being very openly vocal about this. A lot of
yeah,
people are frustrated. We all talk on listservs or in groups and whatever in chats, but nobody's openly and publicly complaining or making it a big deal. And we want things to change, but we're not doing anything for things to change. And it's becoming really frustrating on the defense side because we're just now it's more and more difficult to practice as a defense lawyer. So I want to say, like I'm very proud of you for, for doing this on behalf of the profession. We need more Anitas in the profession. We need more people like you who are actually going to dare to do these things. And like you said, like worst case, they're just not going to respond, right? Like they're not going to give us the information, which we're pretty much expecting at this point. Like we're not
I nobody will be happier to be proven wrong, and nobody will be more shocked if I show up on September 18th and someone says to me, "You know what, Miss Szigeti, you don't need to actually introduce your motion. You've provided notice in writing. We know what you want, and we're just going to share our screen and show you the invoices of the service providers that you've asked for, and not to worry, we promise if we engage anyone else in relation to this fiasco, you'll be the first to know. We'll call you and say, guess what? We hired someone else and it's going to be another 50 grand.
Yeah.
Yeah, it would be a beautiful day if that were to occur.
Yeah.
And we'll see what happens if they even let me bring the motion. There was a little bit of a blip, as you know, I had 11
Yeah.
signatures because they wanted 10, and apparently that meant exactly 10, including mine as the mover. So it was a little bit of a statutory interpretation problem. That got sorted. But I thought they would have to publish motions that they've received in anticipation of the AGM, and I haven't seen it online yet. So I hope that they let me bring my motion. But in a way, there's enough information about this motion out there now that people understand what the issues are. So let's hope for the best. But you raise an important thing, and I just want to clarify to you because there are good people in convocation. So once again, the comments that I make are just generalized about our governance structure, the disconnect between venture election platforms and then what they see as their job and role and how their hands are tied and what they're bound by when they get there. And this is not personal to any individual venture
Mm.
at all. And there are lots of them who go to great lengths to consult and to involve associations and are representative when they speak. And I've been watching Convocation TV. So there are fighters within Convocation. There are people who hold their hand up, disagree, and they're not all, sheep or lamb or I want to say lamb to the slaughter. But um, the problem you identify is this, and you say there should be more people like me. That's very nice of you, Maya. We're friends, so you think that because you like me. But I remember making the comment to what I thought was a good friend and colleague at the time, some number of years ago, that I simply had no interest in becoming a judge. And that friend and a colleague who's now a judge said, well, that's lucky because it's not as if you've conducted your career so that that would be an option. And I thought, well, that's a terrible thing to say, but it's also true. So I've always spoken truth to power. And I've never had any interest in a judicial appointment myself, and that's never going to change. Um, but I'm at the end of September, on September 24th, I'll be questionably celebrating 33 years at the Ontario Bar, which means I'll be in my 34th year of practice as of September 25. And I have seen a lot of my friends, almost all of my friends at my stage of my career become judges. And I've seen a million other people become judges, and I've seen how they behave in the years that lead up to their appointments. Lots of other people who never got the appointment, but nonetheless spent, 3, 6, 9, 12 years trying to get appointed. And because that process of vetting people for judicial appointments is so invasive, because the Judicial Appointments Committee has the ability to call anyone that you've ever crossed paths with, not just people you prefer as your references. Um, when people decide they want to seek a judicial appointment, they have an application in to be appointed a judge. They stop saying anything to anyone that could possibly upset anyone, basically. It's not just about making public statements or making political statements. They really stop having any interpersonal conflict as much as possible for fear that that person will get that call and will not support their application or will make comments in those confidential conversations that will diminish their chances of that judicial appointment. When people are that afraid to speak truth to power, to speak their mind, to raise hell when it needs to be raised for the administration of justice, when people are that afraid to do anything except put their head in the sand and head down, do their work and not upset anybody, they should not be in any position of power or authority because they're not going to be able to act in the interest of the administration of justice. They're not going to be able to advocate fully. They're not going to be able to speak their truth. And they're not going to be able to represent vulnerable people or disadvantaged lawyers or any other cause that matters even to them, no matter how much it matters to them. And so it's my view that when running for election as bencher, if there is an election and you are a successful bencher candidate, you must not have an active judicial application pending. And that would be, if it were up to me, that would be the first rule that I would implement. And honestly, I think the reverse is true. I think it's almost like a de facto criterion of the application that you have a judicial application pending because I think 8 or 9 people who were elected 2 years ago have been appointed to the bench
Mhm.
of that convocation group. So I'd really like to know out of the 40 bencher members, how many have active judicial applications in? Because I'm prepared to bet it's most of them. It's a direct
Well,
stepping stone.
I think many actually become benchers because they hope that it will help them
And it
secure
and it
a
does.
judicial
And
appointment.
they're not wrong. They're not
It's
wrong.
like
It
people
does.
who get into, like many of the associations as well and boards, like it's everything is being done with this obsession of getting a judicial appointment. There's nothing wrong with getting a judicial
No,
appointment.
it's
I mean, you
fantastic.
need to be a lawyer before you become a judge. So we need lawyers to be lawyers and then become judges. That's not the issue. But the issue is you don't stop doing your job as a defense lawyer while you're still a defense lawyer because you're obsessed with something that you still don't have. And I understand that you don't want to ruin your chances. And unfortunately, what we're seeing right now, comments from the government don't really help, right? Like when we see, like comments that say, well, we want people who think like us. So people want to,
I actually think those comments would be liberating for the defense lawyers who are seeking judicial appointments in the provincial courts, like in the Ontario Court of Justice right now. If you have an application in, you're a defense lawyer, you have an active application to be appointed to the Ontario Court of Justice, I think you might as well scream, anti-conservative government messaging from the rooftops because it's not going to reduce your chances of being appointed any more than the fact that you're a defense lawyer. Like we are seeing every week judicial announcements of only Crown
it's
appointments
true.
to the Court of Justice. No, obviously to suggest that only Crown attorneys should become judges in our criminal trial courts is an outrage. It's an offensive outrage. And the consistent and persistent appointments of only Crown attorneys, even the people who were once defense lawyers will only get those appointments if they
If they
put in
become
5 minutes
of
as a
being a
Crown right
crown.
before their appointment.
Yeah.
And that's ridiculous. You have all these defense lawyers who are going over now to be crowns just so that, their judicial application has a chance of being considered. And this is all very twisted. Um, but no, becoming a judge, we need smart judges. We need fair judges. There are lots of benchers in convocation who would and will be wonderful judges. I just don't think that governing the profession should be the one guaranteed stepping stone to a judicial appointment because I want the people who are governing us to be wholly independent of our government and to be unafraid and not to be burdened by fearfulness that the wrong utterance or the wrong vote is somehow going to ruin their life and ruin their career. So they're free to, this is how I would want to see it. You can apply to the bench until you're appointed as a bencher, you withdraw that application while you are a bencher, and then you can reapply. And if your service as a bencher in convocation for those 4 years that you were elected for helps you with your judicial application, and when they consider your application, they say, this one was a bencher for 4 years, then more power to you. That's how it should support your application, not we elect you and 5 minutes later you're appointed a judge, and you're appointed judge while you're a bencher, supposedly acting independently of the government, independently of political pressures.
Mhm.
And you should be able to fearlessly and publicly advocate for access to justice issues, administration of justice issues, and not worry about how you're being perceived.
Yeah.
It's not good. That's why the Criminal Lawyers Association, if you want to be the president, you can't have an active judicial application in, and that is one very, very good and very smart rule.
Yeah.
So yeah, I agree with you. I agree with you that fearless and zealous advocacy, not just for our clients, but for the administration of justice, for fairness of trials, for fairness in adjudication, for fairness in the judicial appointment process. Fearless and zealous advocacy is our job, and anyone who's hampered and impeded in that because they have an active application to the judiciary um, needs to not hold these positions of power where their job is to be outspoken in the interest of justice. That's what I think.
So, Anita, for people who want to support you on September 18th, what can they do?
Please register. And so the Law Society's website has a latest news tab, and the most recent posting there is about the annual general meeting on September 18. In order to attend virtually, you must register. It's very simple, just your name and Law Society number. I think they probably vet you if you're make sure you're not suspended, although suspended people should be able to attend, they just shouldn't be able to vote. My understanding, and I could be wrong, is that if you do attend virtually, everyone who attends is able to vote on a motion before convocation. So it's not just the benchers who vote on motions brought by licensees, but everyone. I hope that's right. It's pretty hard getting sort of straight answers about what happens there. But even if for some reason you don't get to vote, I would like to see your smiling face there. I think it would be good to have a show of force. I think Law Society desperately wants us to forget this ever happened.
Mhm.
I'm sure they're wildly irritated about the motion, even if simply because it's a reminder of what happened. I do think that, and they say this, they want to move on. They want to move on, and they hope that we don't remember this stuff come the next election. Um, but we do remember. And I would like them to look at my motion, my little motion, as an opportunity to surprise us all, an opportunity to be transparent and say, you're asking a reasonable thing. It's your money. You want to know how much money we spent, what this is costing us, costing you. Here you go.
Yeah.
This is the total. I want them to surprise us. I want them to be transparent. I want them to shut me up and silence all of our complaints. And
Well, and that's the best way for this to go away, right? Like
well,
if they
it
say,
would have been
yeah,
if they done
if
it
if
that
if
way.
if they
And
want this to go away, then just give us the answers
just
and that's
disclose.
it. And then we'll just, like you say, we'll shut up and
Yeah.
we'll move on. But
Yeah.
if we still have unanswered questions, we're never gonna be satisfied.
Well, I guess, what's that movie, Dumb and Dumber,
Yeah.
where Jim Carrey, I think, says, "So you're saying there's a chance?" When she said, "Not a, there's a snowball's chance in hell," or whatever. So, I mean, to the extent that there's a snowball's chance
Yeah.
in hell, that they'll actually give us the information I seek. I guess, they're saying there's a chance. I hope so. So it would be nice. I think the profession is angry. It's an hour or two out of your life. The AGM is interesting to watch anyway. Watching convocation that's streamed publicly, I find fascinating just for the dynamics alone. And I have a lot of opinions about that for another time. But I think, you're a practicing lawyer or paralegal. These people control your professional life. So give us an hour or two of your time on Thursday, September 18th. Join me. I feel like I'm hosting the party. I realized I was on social media going, please join me at the Law Society's AGM. Like, I'm going to be serving drinks like it's my party. No, it's the Law Society's annual general meeting. And if they let me introduce my motion, if they let me speak, if they let you vote on it, I would be very delighted if you would come and do that. And in no way will you be advancing my judicial application. That's not happening. But it would help. I think it would help whether to cause them to be transparent and disclose the information, or just to, embarrass them for not doing it. And that's also fine if that's what occurs at the end of the day. Is then they have to hire management consultants to deal with the fallout of refusing to give us the information,
Yeah.
the invoices.
Yeah.
That'll be
Yeah.
next year's motion. One thing at a time.
One thing at a time. Well, thank you so much, Anita, for taking the time to explain to us
Anytime.
the motion and how we can support. And to anyone watching who will be watching this, I encourage you to please support Anita with this motion. She's doing this, you don't have to do anything. She's doing this on behalf of us all, but all we ask is for your support. So you just need to register, attend. The motion has already been signed, so we don't need signatures at this point. You've had more than what was required, as you just mentioned.
An
But
embarrassment of riches.
and
I
yes,
actually had a backup. I had several,
yeah.
very organized about it.
But I'll so just please register before September 18th and make sure you attend and you support Anita with this motion. And again, it's information not just for Anita. Like, I know she's very curious, she wants to know, but we all have an interest in knowing so that this doesn't happen again and so that we can try to restore our relationship and our trust in the law society. Hopefully we will get to that point, but things have to change for this to happen. So thank you so much, Anita. It's always nice to see you. And I honestly look forward to what's going to happen on September 18th. Let's see.
Me too.
Yeah.
Well, it's never a dull moment, Maya, with
No,
and I think it'll be fun. I've done it once before in '94. I brought a motion to the AGM, so I look forward to being able to address convocation if they will permit me to do so.
hopefully, fingers crossed. Bye, Anita.
Thank you, Maya.